And welcome to Employment Hour in 30. I'm John Scholes, co-host Lior Samfiru. He is the guy with all the brains and all the answers. I just sit here and I try to look good each week, but I'm still working on it. It's been a
continue to work on it.
It's been over a year. Contact for you, 1-855-821-5900, or simply help@employmentlawyer.ca through email. Lots to go through on the show today. We'll get to the severance pay calculator, as we always do. A handy-dandy tool. That's his quote, not mine. That's what he calls it. It's free. It's easy to use. Check it out in the meantime, severancepaycalculator.com, before we get in depth in that regard as well. Everything you need to know about wrongful dismissal. We'll get to that list in just a little bit, and some phone calls from our Employment Hour radio show. That is all on the way, but we start each week anyway with the week that was, something that's been happening in the firm with you, my friend. So what's going on?
Well, it's been a busy time. A lot of people are calling. People watch this show right here, and it triggers something, a question, an issue, something that they want to know about, and they call and they email. That's great. That is tremendous. That's exactly why I'm here. I'm not going to be able to cover every topic of employment law in the 30 minutes that we're on air. So you may have questions about your specific situation, something that we haven't covered or something that we can't address fully. So reach out. Call me, email me. You'll have that contact information throughout the show so that you can do just that, and we can sit down and discuss and make sure that there's solutions and there's comfort that you have if you're dealing with a workplace problem. So that's really what the point of this is, to make sure that those problems are alleviated. Now, let's start with the week that was. Let me tell you about a matter that I dealt with this week. Well, first of all, John, we've talked on the show before many times about maternity leaves, and I think it was you that coined the beautiful phrase,
"Don't mess with mama."
You don't mess with mama. But we have to be fair, and we can't forget about Papa. We can't forget about the fathers. Yep. And this matter that I dealt with this week was a prime example of that. I spoke with a gentleman who told his employer last year that he's going to go on a parental leave. And his employer was not very happy or very receptive. They tried to make him feel bad. They said, well, wait a second, we're very busy. We have a small team here, so it's going to impact us negatively. Do you sure? Maybe you cannot do that. And by the way, that's wrong. Your employer should never do that. Well, he did go on a parental leave. And 2 months before he's scheduled to come back to work, he's called into a meeting and said, we've decided to make some changes. Your job is no longer available, so we don't have any more work for you. Now, the interesting thing is that his position was still there. In fact, they were looking to hire for that position, and someone else had retired, so there was plenty of work for him to do. They simply decided that they don't want to. Right. He called me, and he wanted to know, can they do that? He had a feeling that they couldn't. And sure enough, of course they cannot. Fathers, mothers, it's the same thing. You have to get your job back at the end of the parental leave. The same job, same pay, same responsibilities. Company can't decide that they don't want to. They can't decide that they'd be better off with someone else. They can't decide to keep your replacement. They cannot do that with the parental leave, with the maternity leave. That's illegal. Violation of the Employment Standards Act, violation of the Human Rights Code, not something they can do. So number one, big problem for this company. They did that. There's really no excuses. So they're going to have to pay damages for doing that. Okay. Beyond that, even if we forget about that for a second, the severance that they offered him was completely nonsense. It was about half of what he was actually owed. So not only did they violate his human rights entitlements, they also wrongfully dismissed him. Big deal. Bad thing for the company to do, and I wanted everyone to remember this. You cannot be let go if you take a parental leave. You have the right to take that leave. Fathers, mothers, it's the same thing. You can't be threatened, you can't be penalized, you can't be made to feel bad, and you certainly cannot be fired if you do that.
Does the company have any recourse as find of someone they get to replace this guy while he's off on parental leave? This guy turns out to be an absolute rock star, and they want to keep him. They're going, oh, he's so much better than the original guy. I mean, it happens, right?
It does happen.
What leeway do they have, if any?
Very, very little. No leeway, really, when it comes to parental leaves, when it comes to maternity leaves. They can't say, well, the replacement is better than the original person, so we're going to keep him. No. Hopefully you can find another spot for that new superstar that you hired, but you still have to bring back the employee on parental leave. If you don't, that's illegal, and an employer that does that is going to find out very quickly that the law is going to come down pretty hard on them.
EmploymentHourTV.ca is a resource to find where you can catch our radio show, which is in its 7th year now. We've been doing that a long time. We got a ton of phone calls on the show, as we've mentioned before, and we take the good ones, we cherry pick the good ones, and play them back on this show, and we get you to reflect and comment on those, my friend.
My brother was in an accident. He has been disabled permanently. He's had some time off, but the long-term disability program that he had with his benefits, it was covering him while they were there. They've cut him off, and now the company has brought him in, and they had a sit down, and they've offered him 17 weeks severance, and they said that they are not going to be hiring him back. He said that he wanted to return to work. He kept telling them that. Is there anything that he can do?
And how old is he?
I believe he's 52 now. He worked for a construction company, 4 to 5 years.
Had a sit down.
Sit down.
The Sopranos.
Yeah.
It's never a good
Have a
thing.
seat.
Have a sit.
No, it's there's a lot to unpack here.
Yeah.
So before we even get to his employer, let me talk about the disability insurance company. He says that they were cutting him off, and presumably if they cut him off in a time when he's not ready to go back to work, when his doctor says he should be still there, that's a problem. That's not something they can do, and that's a very common situation. People that are on LTD and they're trying to get better, they're following their doctor's advice, and all of a sudden the insurance company says, well, we don't think you're disabled enough, or we've decided you can go back to work. No, they cannot do that. Happens often, but cannot do that. That's illegal. You need to deal with that. It's not that difficult, actually. Usually once we get involved, we can get the insurance company to do what they're required to do. So if you're ever in that situation, you've been cut off a long-term disability, before you're ready to go back to work, let's talk. Give us a call. I have a team of lawyers in my office to deal with that exclusively. But let's now talk about the specific employment situation here. His employer says, well, we're not going to take you back. We're going to let you go. Well, if the decision to let him go has something to do with the fact that he took a medical leave, that's illegal. That's a human rights violation. You can't do that. You can't let someone go because they had a disability leave. It doesn't matter how much severance you pay them. So right off the bat, we have a human rights violation. Now, beyond that, let's go to the third issue, which is the severance. So number one, problem with the long-term disability. Number two, human rights violation. They can't fire him because he was sick. But now let's talk about the severance. So he was offered 17 weeks pay after 4 years of employment. Is that right? Well, let's talk about that. Let's actually, before I even talk about it, let's plug that into the severancepaycalculator.com website to see what this person's actually owed. So 4 years of employment, 52 years of age, was offered 17 weeks. Severance pay calculator correctly assessed him as being owed 6 months pay. So, 50% more than what he was actually offered. Right. Significant, a big deal. So it's a wrongful dismissal as well. So what you see right now is kind of a screenshot from the severancepaycalculator.com website. Anyone can do that. We'll talk about that more later. So this person has been wronged by his insurance company, by his employer. He's owed compensation, and he needs to give me a call.
The drag about this whole thing is people in that similar situation will say, oh no, the insurance company says I have to go back to work, and they're going to go. They don't know any better. They're going to go.
They're going to go. And what's going to happen when they do that? They're probably going to hurt themselves even more because they weren't ready to go back to work. So when it comes to going back to work, you have to follow your doctor's advice. Your doctor's advice. Not what the insurance company says, not what your employer says. Your doctor's advice. If your doctor says, yes, you are cleared, you're ready to go back to work, great, have at it. But beyond that, if your insurance is putting pressure on you, we need to deal with the insurance company. If your employer is putting pressure on you, we need to deal with the employer. You cannot and should not go back to work before you're ready, before a doctor clears you. If you have any questions, any problems, anyone pushing you to do something you're not ready to do, you really have to reach out to me.
Again, employmenthourtv.ca is the place to find that radio show where we get these phone calls from. Call number 2 coming up right now.
I was working for a building supply company for a year and 3 months. I was a truck driver. I'm 40. Came back from a holiday, and they said, sales are down. We're going to lay you off. We may or may not call you back. But after about 28 weeks, they said, we're not going to be calling you back. They gave me 2 weeks. And then I found out through a source, a friend of mine that still works there, that 2 weeks after they paid me out, they posted an ad for my job.
So much for temporary layoff.
So much. That's nonsense. Now, usually when I get a call like this or an email or someone contacts me, they're upset about the lie. They're upset about, oh, we're letting you go, but we're hiring someone else. It doesn't sound right, right? Why are you letting me go but looking to hire me? What have I done wrong? Yeah. And I understand. I would be just as upset if it was me in my position. But the reality is, from a legal standpoint, strictly from a legal standpoint, they're allowed to do that. They're allowed to let you go and hire a replacement, even if you haven't done anything wrong. Maybe they want to hire their cousin because their cousin needs a job. They could do that. It's not right, but they have to pay severance. Yeah. Now, for this person, when he was supposedly laid off temporarily, that temporary layoff in itself was a termination. He doesn't have to sit at home and wait and hope that they'll call him back. He can treat that as a termination right away on day one and get his severance. Ultimately, he's owed much more than the 2 weeks' pay. Even after a year, depending on his age and position, he could be owed 3-4 months' pay, maybe even more than that. So he's owed much more compensation. And that's what it ultimately comes down to. I know he's upset about being let go and being replaced. Not much we could do about that, but we definitely can get him proper compensation. 2 weeks, not even close to being enough. And of course, if that's your situation, temporary layoff, remember, that's a termination. We need to speak about it. And if you've been offered severance, chances are, I can almost guarantee it, it's completely inadequate.
The temporary layoff is not a legal mechanism. It doesn't exist. It's a termination. But now he's already been through it for 28 weeks. Can he still take advantage of it?
Well, yes, he absolutely can. The termination happened when it did. He could have dealt with it 28 weeks ago. He didn't, but we can deal with it now, get him his severance right now. And certainly I would say to someone, don't wait 28 weeks because you're not getting really paid in the meantime. I would much rather you get paid now, move on to a different job, and not have to sit at home, wait and hope that they'll call you back at some point.
1-855-821-5900 is that number to reach out, get a hold of Lior, member of his team. As mentioned off the top, we will get into this now, and that is everything you need to know about a wrongful dismissal, right?
Wrongful dismissal, a term that's used often, it's often misunderstood, so we want to demystify that so people know if they've been wrongfully dismissed and what to do.
First question, obviously, what is it? What's a wrongful dismissal?
So when I say wrongful dismissal, when people hear the term, they assume that it means something to do about the termination was wrong. It was wrong to let me go. They shouldn't have dismissed me. Usually it has nothing to do with that. A wrongful dismissal really doesn't get into whether or not they were right or wrong to let you go. The reason for that is a company is allowed to let you go as long as they pay you severance. So wrongful dismissal almost always is a question of severance. So you've been wrongfully dismissed if you've received an inadequate severance or you've received no severance. That's a wrongful dismissal. If the company has a terrible reason to let you go, John, I don't like your tie, so I'm going to let you go. If I pay you your proper severance, that's not a wrongful dismissal. Okay. That may make me unreasonable and maybe not very bright, but that would not be a wrongful dismissal. That comes down to severance.
It's actually a nice tie. You have the same one. I think you wore it last week.
I won't let you go because of your tie.
Everything you need to know about wrongful dismissal. So just being a working stiff out there, how do I know if I've been wrongfully dismissed?
Well, here's the thing. I mean, as absurd as this may sound to some people, 90% plus of people, when they're let go, they've been wrongfully dismissed. Even if they have the nicest employer, even if they love their employer and they leave on good terms, most people are wrongfully dismissed because most people are offered inadequate severance. So if you've been let go, chances are over 90%. I've been doing this for, 16 years now. So I've spoken with literally thousands of people, and I've seen thousands of other severance offers. So I can tell you, you've likely been wrongfully dismissed. You're likely owed much more. Severancepaycalculator.com is a tool you can go to check that out. So it's your job, if you're the employee being let go, to make sure that you haven't been wrongfully dismissed, to find out what you're owed. Are you owed more bonus? What about your benefits? Yeah. How about commissions, your pension? Is that being properly addressed? If all those things are not properly addressed as part of your separation package, that's a wrongful dismissal.
So how common is a wrongful dismissal? Out of 100 cases that come into the office, how many would be?
Most of them.
Wow.
I would say almost all of them. My gosh, it's very, very common, John. It's a shame. If I speak to someone and they haven't been wrongfully dismissed, in other words, their offer is appropriate, I'm surprised. I'm calling my neighbor, my colleague down the hall and say, hey, I actually spoke to someone today who had a good severance package. That's how rare it is. And if you may now, right now, John, there's people that have been let go in the past and are watching us now maybe for the first time, and they're thinking, oh my gosh, are you saying that when I was let go 3 years ago, I was really wrongfully dismissed? Yeah, that's exactly what I'm saying.
Everything you need to know about wrongful dismissal, that's what we're talking about. So difficult to resolve, a wrongful dismissal?
So usually wrongful dismissal will be in two categories. Either a situation with a termination without cause. Right. In other words, we're letting you go for our reasons, we're paying you severance. Or a situation where you've been let go supposedly for cause, because supposedly you did something so bad, and there really isn't cause. You didn't do something that rises to the level of cause. In both of those scenarios, it's not difficult to resolve wrongful dismissal cases. People, I understand, often are afraid of lawyers. They're afraid of the legal system. And everyone hears horror stories. Oh, my gosh, I had to fight someone for 3 years, and it cost me this amount of money. And I understand that. And there are some legal issues where that could be the case. Not usually when it comes to employment law. Not usually when it comes to wrongful dismissal. In most cases, these matters are easy to resolve. Oftentimes, a letter or two, it's all that's going to require. You're not going to be dealing with this a year later. You're not going to have to spend a lot of money in legal fees. In most cases, there's going to be no legal fees when it's all said and done. So don't let the fear of the process dissuade you from pursuing your wrongful dismissal entitlements.
So maybe some of our viewers now are watching this, listening to these points, going, you know what? I might have been wrongfully dismissed. I might fit into that category. What do they do?
Well, the first question is, what don't you do? What you don't do is you don't sign off on that severance letter. Even if you think, oh my gosh, I did something wrong and I'm lucky to have been offered anything, so I'm going to sign off. No, because you still may have significant entitlement. So you don't sign off on that severance letter. You go to severancepaycalculator.com. You call me, you call another employment lawyer. If you don't want to call me, that's okay. But you cannot sign off and then later on you realize that you're owed more. Once you sign off on that piece of paper, it's too late. This week alone, I spoke with 3 people who contacted me after they signed off on the letter, and they all felt pressure. They all thought they had no choice. They all were worried about supporting their family, and I get that. So they signed under pressure, but still, once you sign that piece of paper, it's too late. It's your job to make sure you get what you're owed. So if you've been let go, chances are you've been wrongfully dismissed. You have to get some advice.
Coming up here, when to avoid the Ministry of Labor, and of course, we'll get into the severance pay calculator next after a short break. 1-855-821-5900 and employmenthourtv.ca as well. It's the Employment Hour 30. Stick around. We're coming right back. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com. Yeah, welcome back to Employment Hour 30. It's that time of the show where we talk about a little secret. Well, it's a secret to less than 500,000 people, but that's okay. Severancepaycalculator.com, the one place you want to go. You want to find out exactly what you're owed. When it comes to your severance, don't sign anything. Don't make another move till you go there, but we're going to talk about it right now.
Worst kept secret ever. Okay? Over 500,000 people used it, so not very good secret.
Right.
But gosh, as many people as have used it, there's even that many more people that have never heard of it, have not used it, so you need to know about it. Severancepaycalculator.com. We touched on it in a previous segment. It's the place you go to if you lost your job. It's the place you go to if you've been wrongfully dismissed. Remember, wrongful dismissal is simply a situation where you've been let go with inadequate severance. So once you've been let go, once you have that piece of paper to find out, the easiest way to find out how much you're actually owed, you go to severancepaycalculator.com. In seconds, you'll find out. You'll answer a question about your length of employment, your age, the type of job, and that's it. You'll find out whether the 6 months pay that they offered you is adequate. Spoiler alert, it's not. And it's anonymous. It's free. There's no strings attached. You don't have to put in your name. If you want to, there's a green button there you can press to contact me once you have those results. But it's information you need to have even if you haven't been let go. Even if you're not even thinking that anything's going to happen, be armed with that information. Have it. Be knowledgeable. Tell others about it as well. Severancepaycalculator.com.
Also in employer mode, if you're an employer and looking to let somebody go, you want to know what you should be giving them the right amount of compensation. Severancepaycalculator.com. There's an employer mode there as well. Always good to lead by example, though. We'll get to one and we'll run it through. Lior, I know you want to comment on this. Joyce worked as an executive assistant, earning $62,000 a year. Good salary. When the vice president she had been working for 13 years was unexpectedly let go. They let her go as well. She's out the door. Her severance package was 5 months of pay. Should she try asking for more?
Well, 5 months, roughly, 20-ish weeks or so. So she's been there for 13 years. Many would say, well, 13 years, she got 20 weeks. That's more than a week per year. That's not bad. Well, it's bad. And let's put the information in severancepaycalculator.com right now to find out how bad it just is. So, well, executive assistant, 13 years of service, 54 years old, offered 5 months pay. Very common. By the way, this is a real scenario. Severance calculator correctly assesses her as being owed 14 to 18 months pay. Months, not weeks. Now, at her salary of $62,000, that's a difference of 46 to 56. So about $50,000 shortfall. $50,000. That's an incredible amount of money. And we didn't pick this example because it's unique. We didn't pick this as an example because there's something special about it. There's nothing special about the situation. This is a very common occurrence. And if that doesn't make the point as to why people should go to severancepaycalculator.com, I don't think anything will. So she's been wrongfully dismissed. She's owed much more. She hopefully did go to severancepaycalculator.com, realized, no, 5 months, that's not even close. That's a third of what I'm actually owed. That's how it works. It's that easy.
Severancepaycalculator.com is where you want to go. Our live Employment Hour radio show can be found anyway at employmenthourtv.ca. We get the phone calls from the show, play them back here, and we talk about it. We'll get to a call now.
Yep.
Myself and about 13 other people worked for a company, and after about a year, things started to go sour. He finally closed his doors. We all went to the Labor Relations Board. We were issued an order that they had to pay us, and he's finding every avenue to avoid paying us. Can anything be done about that?
Yeah, you bet.
Yeah, and you know, the short answer is no. Nothing can be done about it. And the reason for that is, and this is going to sound terrible for those that haven't heard the show before, it was a mistake to go to the labor board. You cannot go to the labor board if you lose your job. And that doesn't make sense, right? Because you think, I could go to the labor board. I've been let go. Something wrong happened to me.
It's the labor board.
It's the labor board. I'm not going to some guy on the street. Yeah. I'm going to the labor board because there's an employment labor issue. Well, no, unfortunately not when it comes to losing your job. By virtue of going to the labor board ordered the employer to pay severance. It's the minimum severance. It could be a tiny fraction of what they're actually owed. So these individuals, for example, could have been owed a year's pay. The labor board would have ordered 8 weeks' pay. So it's a terrible situation, and it gets worse. By virtue of going to the labor board and filing a complaint with the labor board, you're now prevented
from go back.
You can't go back. You can't say, okay, you've convinced me, Lior, that was a bad idea, so I'll just hire you now to help me. I can't. Once you've filed a complaint, once you file something with the labor board or the Ministry of Labor, you're out of time. You can't deal with it. You're stuck in that process, which results in payment of a tiny fraction of your entitlement. So it's a terrible situation. And beyond that, it's even when the labor board orders that nominal amount for you to get paid, it's very difficult to enforce this. So it's a terrible situation. There's nothing, unfortunately, that I could do as much as I'd like to help these people. I get calls like this all the time. I get emails like this all the time. So now that you've heard us say here, don't go to the labor board if you lost your job. You cannot. If you have an overtime issue, no problem. If you have a vacation pay issue, not an issue. Absolutely contact the labor board. Not if you lost your job.
Coming up here, we'll get to why you're likely wrong about severance for federally regulated employees and why you should think twice about that social media post. That is all on the way on Employment Hour in 30. Hang on. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca. And back with more Employment Hour in 30. John Scholes, Lior Samfiru. Our radio show, employmenthourtv.ca, is the place to find that live radio show. We've been doing that for years, talk to a lot of people, solve a lot of problems, open a lot of eyes, and take a lot of phone calls. Another phone call from the show is coming up right now.
I was given notice on Wednesday, and the reason is restructuring, and I have 7 years of service there, clerical support type work, 57. The severance is 2 paid days for every year of service because I guess my company is under federal jurisdiction.
You get that term all the time. federally regulated?
Most employers across the country are provincially regulated.
Okay.
There are some employers that are federally regulated. Banks, for example, railways, certain transportation companies, telecommunications company. So they're federally regulated, and there's a lot of misconceptions about what does it mean if I lose my job and I work for one of those federally regulated companies. Do I get less severance? You do not. You get the same amount of severance as a provincially regulated employees. Now, your minimum entitlements, your entitlements under the Canada Labour Code, your minimum entitlements could be different, it could be less, but that has nothing to do with anything. Your full entitlements, what we call your common law entitlements, are the same. They're based on your age, your position, and the length of your employment.
Nice.
So to kind of summarize before we talk about this specific situation, if you work for a federally regulated employer, you get the same severance as everyone else, age, position, length of employment. You can go to severancepaycalculator.com just as easily to find out what you're owed. So actions are better than words. Let's actually plug this information from this call into the severancepaycalculator.com website and see how it works. So in a clerical position, after 7 years of employment, age of 57, was given 2 weeks pay. Well, guess what, John? 6 months pay, as you can see on your screen right now, is what this person is actually owed. 6 months pay. Now, I don't know how much money she earns. I don't care if it's $10,000 or if it's $110,000. It's going to be a big difference between 2 weeks and 6 months. So that's how it works, just as easily for federally regulated employees and for provincially regulated employees.
Another place for you to ask your questions to Lior and his team, terminationquestions.com. It's a very simple website to use, drop-down menu. There's a high probability that your question has been asked and answered in depth. If not, leave it there. And I know, Lior, your team gets to it. We'll get to one from, again, terminationquestions.com. As follows: I was fired for cause because of something I had posted on my Facebook page after having a frustrating meeting with the plant manager and my foreman. Is that fair, considering the comments were made outside the workplace?
And, you know, this is a common situation, especially now. We all have social media accounts. We have our Facebook and LinkedIn and Instagram and et cetera. And we think that what we say there is our business, especially if it's off work. Not so fast and not so easy. No, you cannot assume that just because you make some comments on your social media outside of working hours, that doesn't have an impact on your workplace. If you were to go on your Facebook and say, my boss is a piece of this or a piece of that, and he's this, you know, he's a dishonest person, he's a liar, he's a thief. Well, to the extent that that information gets back to your employer, they're going to have a big problem with that, and that would be misconduct. You can't assume that just because you have certain privacy settings on your account that no one's going to know. It doesn't work these days. I've spoken literally with dozens of people who thought they were saying things that are private, didn't know that it's going to impact their employer, and the employer found out about it, and there was an issue. Now, the fact that you may have done something wrong in itself doesn't mean that there's cause to let you go. Okay. So I don't know specifically what this person said. Chances are that whatever they said wasn't bad enough to rise to the level of cause. Remember, it's very difficult to establish cause. But is it an issue that she posted things on her own time? Yeah, it is an issue. You can't say, well, it wasn't during working hours. That in itself is not an answer. So be very careful what you post online, what you post on social media. These things, John, have a way of getting back to the employer.
That's interesting, because most people would say, hey, I didn't do it on a work computer. I wasn't in the office. I was in my kitchen when I did that. I don't see that as being a problem. It's a problem. It's a problem.
It's a problem because you don't know who's going to read it and tell your employer. If your employer knows some of the people on your, say, your Facebook, Facebook friends, is that going to make the employer look bad to them? Your employer has an interest not to have things, bad things said about them, even if it's on your personal account, even if you do it from your kitchen in your own apartment. It doesn't matter. Be very careful with that. Don't give the employer a reason to let you go. But despite that, if you did it and you've been let go because of that, I still want to talk to you. Chances are it's not actually a cause termination. Chances are you're still owed compensation, but the best advice is be very careful.
Like thing in social media, before you hit post, just take 5 minutes, go have a coffee, come back, read it again, and then see if you're going to put it up there, right?
Excellent advice. I've used that advice myself, and I've always been happy that I did. And I think if you can take one thing out of this discussion, I think those words are very wise.
Done for another show. Hope you join us next time. 1-855-821-5900. Help at employmentlawyer.ca and employmenthourtv.ca as well. We'll catch you next time right here, Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.